Hello everyone. In the today's video we have discussed the मेंस क्वेश्चन. ये क्वेश्चन मेंस में आया हुआ है और बहुत इम्पोर्टेंट क्वेश्चन है. दैट प्रिंसिपल ऑफ क्रिमिनल लाइबिलिटी. इन प्रीवियस व्यू it was that the accused will prove his innocence, but the present view, which was emerged from the landmark case Woolmington versus Director of Prosecution 1935 All England Reporter, the presumption of innocence have been emerged. It is that burden of proving guilt of the accused is on the prosecution. So the conclusion of the criminal jurisprudence principle is that who moves to the court of law, that person proves the guilt of the accused, and it must be proved beyond reasonable doubt. On the principle of criminal liability, the Indian cases are S.L. Goswami versus State of Madhya Pradesh, 1972 Supreme Court. In this landmark case, the Supreme Court had said onus of proving all ingredients of offence is on the prosecution and this burden is never shifts. Then what is reasonable doubt? There are two famous cases on that. First, Himachal Pradesh versus Om Prakash 1972. Then Daya Bhai Chaggan Bhai Thakkar versus State of Gujarat 1964 Supreme Court. In both the cases, Supreme Court had said that reasonable doubt is that doubt which any reasonably prudent man will act upon. Then the exception of this rule is 103, 105, 111A, 113A, 113B, 114A of sections of Indian Evidence Act which are based on the public policy. It held that the accused will have to prove his innocence. So this is all about today's lecture, and this is a very important and famous principle of criminal liability and the previous year mains question. Thank you.